I'm Tony Mealy, and this is the Coach Lone Wolf podcast. We're a community interested in innovators and how they make their way in the world. Our guests are entrepreneurs, intellectual property specialists, athletes, martial artists, inventors, artists, and others. Today, Ken Fagin is joining, and Ken, he's an old friend. We both worked at the same law firm a few decades ago, and he's the founder and managing lawyer for KMF Patent Services, PLLC, and he's based in Gaithersburg, Maryland, right? Is that right?
Well, the firm is officially registered or set up in DC, but I live in Gaithersburg,
Okay,
which is about 9 miles up the DC, 270 from the DC Beltway.
nice. So he's in the Washington, D.C. area. He has a Bachelor's of Science from MIT in Aeronautics and Astronautics.
Right,
And he got his law degree at Washington University in St. Louis.
correct,
And the firm that we worked at together was Pillsbury Winthrop in the Northern Virginia office way
correct.
back. He also worked as an engineer for a few years at McDonnell Douglas.
Correct.
And yeah, that's my initial introduction. Nice to have you. Thank you so much for coming on, Ken.
That's all there is to know about me.
That's all there is to know.
Yeah,
We'll pull some other stuff out of you
we will. We'll, we'll
the
get
next
there.
little while. So tell me about, where are you originally from? Where'd you grow up?
I grew up in St. Louis.
St. Louis?
Yeah, St. Louis, Missouri. Born and raised.
What was
Went away
that
to
like?
MIT, as you mentioned.
Yeah.
Went back to St. Louis and worked at McDonnell Douglas, which is there in St. Louis now.
What was St. Louis like when you grew up there?
Oh God. Probably a lot like it is now, still in the area that I grew up.
Yeah.
There are pockets where it can be a little rough. We've seen on the news in the past few years of things that have happened. But out in the county, it tends to be a little bit on the liberal side.
Is it
Uh,
rural or
Progressive.
urban?
No, suburban. I grew up in suburbia.
Mm-hmm.
I'm a suburbia kid. Uh, Good baseball city, good hockey city.
Okay.
It was a decent Midwest upbringing.
Nice. And you stayed there until you went to MIT?
Right, right.
Then you went to MIT in Boston or Cambridge. When you were younger, what did you like to do? Like sports? What were your favorite activities when you were younger? Growing up in St. Louis?
Consistent with the aerospace, the interest in aerospace, I was into model rocketry.
Oh, really?
Yeah, working with my hands, a lot of model building. Um, Normal kid stuff. No, I was not a super athletic kid.
Yep.
Um, Normal kid stuff, I guess.
Yeah. Did you try, like we used to do, we would do these jumps with our bicycles,
I did.
the big banana seats?
The Schwinn with the shifter. We did those.
Oh, wow.
Yeah, yeah. We're dating ourselves here,
I
aren't
think
we?
I was in fourth grade. Actually, I was maybe third or fourth grade. I was pretty young, and these friends of mine said that I could be a member of the Evil Knievel Club if I took my bicycle to this top of this hill, and it was pretty steep. It was like a little cliff, and I had to ride my bicycle down this hill, and no one else did it. Like looking back, I never saw anybody else to do this, but I did it. And I came down, went up, went head over. The bicycle came down on top of me, and I got some bumps and bruises. But I was in the Evil Knievel Club.
Congratulations on membership.
Thank you, thank you.
Yeah, my younger brother had some friends and they were into BMX. They had a bunch of BMX bikes that they did the jumps with. I still remember they set up a ramp on
Mhm.
like a piece of cement sewer pipe that they found somewhere. And I had graduated to a 10 speed at this point. And I did the jump on a 10 speed, like went flat over on my back. And that was the end
Oh
of it.
my God.
Yeah.
I was
Yeah.
around the same time. I remember we went to the woods, and these friends of mine found this natural vine, and then they were swinging from the vine, and then I decided to try it. So I grabbed it, and I jumped on the vine, and at that moment that I got up on it and swung, the vine let go, and I just went. I thought my life was over, and I fell flat
Yeah.
on my back. And actually, I was fine. The ground was fairly soft, and I was fine. Um, but the types of stuff that we used to do back in the day.
Yeah. Yeah. Surprised we survived it.
Exactly, exactly. Go home when the street lights came on. We had to go home. That kind of stuff.
Yep. We're
I
dating ourselves, Tony.
well, everybody was a kid, so we're not admitting any particular years. We're not naming any particular years. We're just saying ages.
Yep.
So 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 you went to high school in a suburb of St. Louis,
Yeah. Chesterfield, Missouri.
Chesterfield, Missouri, and what kind of stuff do you like doing in high school?
I was math science oriented.
Yeah.
Yeah. I wrestled a year. You asked about sports. I wrestled a year.
Oh, you did?
I did.
What was that like?
I went in half expecting some of it to be like pro wrestling, honest to God.
Oh, really?
Yeah. Um, I mean, I kind of realized it wasn't really like pro wrestling, but there was an element of it's like, yeah, because I used to watch a lot of pro
What
wrestling.
year in high school were you in when
I
you
was
did it?
class of '83,
But were you a sophomore or junior? Which year?
sophomore. I was
Sophomore?
not very good. I won a single match.
Did you do the
Everything.
whole season? You
Yeah.
did.
Yeah. I
So
was
you,
1-9.
so that's a tough workout.
There are some kids that were really pretty good at it.
They work you hard when you're wrestling, don't they?
Yeah.
Like in practices?
I was well, in practices, yeah. Um, where they really worked it was in running. Although
Oh,
I was a heavyweight, I was 205, but as far as heavyweights go, that's sort of the lighter end.
hmm,
But heavyweight, it's sort of free for all. The other defined weight classes, people are always trying to make weight.
mm-hmm.
Whereas you get to the heavyweights, it's like nobody cares about weight anymore. And so there was a tendency to sort of slack off on the running. And, I went against some people that were fairly large. There was a guy I wrestled one match who was probably about 325.
Wow.
And my teammate said, whatever you do, don't shoot legs. In other words, going in at the guy's legs. Um, well, the guy had his, leg forward and I shot legs and he pancaked right down on top of me.
Oh
That was
God,
pretty
yeah.
much the end of the match. So yeah, it was fun. Took some lumps, but
Yeah.
yeah, that was my 1 year of sports. Otherwise, like I said, I was fairly math science oriented.
Yeah, yeah. Um, then you went to, what was Cambridge like? What'd you think of that? Did you like it?
Cambridge was very different than the Midwest.
Yeah.
Boston is an interesting city, and it's interesting that that you specify Cambridge because down here in the DC area, if we're talking to somebody who's not from the area, we'll just say I'm from DC. Whereas in Boston, folks tend to identify very much so, or strongly with their individual little pocket. So Boston per se has a vibe. Cambridge has a vibe,
Yeah.
and all the other pockets in the area each have their own distinct vibe.
Yeah.
Um, Cambridge, MIT straddles Mass Ave, which is like a main north-south thoroughfare, and there's a lot of industrial development around it. So it's sort of isolated from Cambridge per se, or Cambridge proper. And it's a world unto itself.
Yeah.
MIT was an interesting experience um, because you're there with some incredibly, incredibly smart people.
Yeah,
And, you know, it's a unique experience to be immersed in that kind of an environment with other people and see how other people's minds think and see
yeah.
just how smart these people are. So, interesting experience. But then I, went back home to St. Louis and started working at McDonnell Douglas, never really thinking that I would go back to Boston. Um, Maybe to jump ahead in what you were going to be asking me about, um, for me, law school was sort of an afterthought.
Okay, so you finished your degree at MIT, and
Yeah,
then you got a job as an engineer, and then
right.
when did you think about law school and going to law school, and why?
I was in structural engineering at McDonnell Douglas for a year
Hmm.
and felt that it wasn't utilizing the full extent of my degree.
Were you working with airplanes?
Yeah, doing fatigue analyses on the F-18 jet vertical stabilizers, the
Okay.
tails. Um, and so I transferred over to guidance and controls after a year. Thought that would utilize the engineering or the aerospace background a little more fully. I kind of realized shortly after transferring into GNC that engineering per se didn't really resonate with me.
Hmm.
And you can't just say, oh, I want to go back. And so I actually applied to go to grad school at MIT. I felt that I had gotten off the educational bandwagon too soon.
So you were at, so just to make sure I understand, so you were at McDonnell Douglas, you were working on testing stress or fatigue analysis on
Yeah,
certain parts of the plane, and then you switched to control guidance and controls,
yes,
and then you said you can't just go back. What did you mean by that? Did you mean you couldn't just go back to fatigue analysis?
correct. You have to wait 11 months between changing positions within the company.
Oh, but you did like fatigue analysis more than you liked guidance and controls?
I felt more comfortable with what I was doing.
Oh, okay.
And so that's why it would have been a consideration, but it really wasn't a consideration.
Yeah.
And I applied to MIT for grad school and was accepted. And I started, it came
What made you think you wanted to do grad school? Like, why were you thinking about going to grad school?
because I felt like I needed more education to really know what I was doing as an engineer.
Oh, okay. Okay.
And it was about a week before it was getting to be the time to go up to Boston and find an apartment.
Hmm.
And I started thinking, I may not be cut out to be an engineer per se. I mean, I still love technical subject matter, but that's when I started thinking, what can I do instead of being an engineer? And I thought, okay, I've tried A, I've tried B. Let's do what everybody else does when they don't know what to do with their life anymore.
Go to law
Go to
school.
law school. And so, I went to law school at WashU in St. Louis because it was there. It was either going to be WashU or St. Louis University.
Did you did you think you were going to be a patent attorney, or did you think that you just wanted to be a lawyer regardless?
I did not go in knowing that I was going to be a patent attorney. I went in not really having a real good idea of what practicing law was about at all. Um,
Were you
during
thinking?
my during my
Were you
second
were you
year,
thinking? Were you thinking? Like in your mind, were you just thinking, well, I could be a politician, I could be any random type of lawyer, like
no, second year it was second year I took a patent law course.
okay.
Basic intellectual property, patent, trademark, and copyright, and I also took a products liability course.
Hmm.
And so it was sort of a toss up between the two because, with product liability, it does require an understanding of how things work and what went wrong.
So there was something about understanding and using your engineering background that was something that you wanted to be able to incorporate if as a lawyer.
I was considering it, yeah. But, I got a job as a patent attorney or as a summer associate at Fish and Richardson up in Boston. And
Okay,
that sort of set the pathway.
I see. I see. So, but before then, you could have gotten into any area of the law potentially, right?
possibly. The thing about product liability, I was dating a woman at the time. She was not a law student, but somebody from the St. Louis area,
Hmm.
and her family is a very well-known, well-respected personal injury firm. Her uncle or her grandfather and her uncles.
Oh, wow.
And I was considering, like I said, that considering that as a career path. But I saw some of the really grievous injuries that they were working with or that their clients were dealing with. And that I looked at that, and I thought, this might be tough to deal with,
Yeah.
you know, on a day in and day out basis, because you're seeing that some people that really are injured badly. And yeah, I sort of shied away from it.
Were her family members representing the injured, or were they representing the companies that were being sued?
No, plaintiffs.
So so they were representing the people that were injured, the plaintiffs.
Yes, yes,
Um, I see. So they weren't defending. So they're the good guys, so to speak. They're representing the little person
yeah,
that got hurt.
yeah.
Wow. Um, so you how did you get a sense as to what your exposure would be to the people that were injured in those situations?
I
Did you
dated her for 9 or 10 months,
told them
and
stories about it?
stories, or you would hear about cases in the St. Louis area, cases that would make the news,
Yeah,
and so you would see in the news what these particular cases were about.
yeah.
And I still remember one in particular. There was a girl who was like 3 years old that was burned over 90% of her body. That
Oh,
one in particular stuck with me.
yeah. I
So I tried
remember
to see that.
I remember in law school taking torts and and we never got a sense as to how badly people were hurt in any of those cases we discussed in class. It was very
Antiseptic.
I don't know if antiseptic, but it was just very like surface level, right?
Yeah,
But it was all about people getting hurt. Like someone slipped on a banana, some kids playing at a train track, and they get hurt. Um, and I remember my wife at the time. She's she and I aren't together anymore, but she would she would make up these tort facts situations and make up these random cases, and she was really good at it. She wasn't going to law school or a lawyer or anything, but she would make up these fictional fact situations that sounded like the tort cases
yeah,
that we would have to kind of do issue spotting on.
that's
Um,
funny.
so you took a course in intellectual property, and in that it covered patents, and that made you think about getting into patent law before you got your summer associate job at Fish and Richardson,
Yes,
and
that's
then
sort of
you
like I said, that sort of set the course.
sent some resumes out to some firms,
Hmm.
and then got a summer associate job working for Fish and Richardson,
Correct.
which for those listening, Fish and Richardson's a long-standing Boston originating intellectual property law firm, does a lot of patent work. It's been doing it for, I don't know how long they've been around, but for a really long
Well,
time.
well over 100 years.
Yeah, yeah. If maybe, yeah, maybe at least. And big firm, really big firm. How long did you work for them?
The summer, and then 3.5 years, and then
Oh,
I came down to the DC area.
so you finished law school and then joined them
Yeah,
after
yeah,
graduation,
yeah,
and then
yeah.
you came to the DC area still working for them?
No, changed
Okay.
over to a different firm, and
Okay,
this
so
was in '96.
you were working in Boston full time for them for 3 years after law school?
3.5, yes.
3.5 years? I see. And then you moved to, what made you consider moving to the DC area, Washington DC area?
There was a friend of mine who she actually was working at Fish as well. She was working in the IT support group. She had a computer science background,
Hmm.
and she's from DC originally. And I came down for Thanksgiving in 95 and looked around the area and thought, this feels like a better fit for me. It just felt more comfortable than Boston. It's a little more cosmopolitan here than St. Louis, but it
Yeah.
was not as East Coastish or New Englandish as Boston. And so, yeah, it just, the area here felt like a better fit for me.
It you so this friend of yours, did she move to DC as well, or
Yeah, I'm sorry. She had moved back to DC. She lives in Chevy Chase now. She's originally from Bethesda.
and she's a patent attorney as well?
No, she does. She's actually now she does consulting work for Booz Allen,
Oh,
Booz
okay.
Allen Hamilton.
So she had a computer science background, but she did not use that for patents. She did that working on the computer and information technology support
Correct.
for the law firm.
Correct.
I see. I see. Yeah, I when I when I was going to college, my mother told me when I was younger that she wanted me to become a lawyer, and I told her, heck no. Has I
What
didn't.
what what led her to suggest that, and what led you to say heck no?
She I don't know. She just thought I would be good at it. She worked for a lawyer for a while when I was younger, and I didn't like. I had some bad experiences with some English teachers in high school. I didn't like writing, and I just had this view of practicing law that I would have to write a lot
Yeah,
and deal with English majors. And so when I went to college, I decided to do electrical engineering because I like math, I like science, and I didn't think I'd have to write much. And I
that's
think
all we do these days, isn't it?
I think I took one semester of English when I was in college. Um, but when I fast forward to my senior year at Western New England, just where I went to engineering school, um, I only had a few interviews for jobs. They were actually on campus. A couple government jobs. One was for a national security agency. The other one was for the Air Force, and the other one was for the U.S. Patent and Trademark Office to be a patent examiner.
Hmm.
And before I decided to do that interview to be a patent examiner, I started researching what it would be like to be a patent attorney, and then I started considering it. And I talked to a patent attorney that was local, and he told me that it was very lucrative as compared to engineering jobs and compared to other opportunities. And and I knew that if I went to work at the Patent and Trademark Office, it wouldn't make any sense unless I became a lawyer, because the starting salary as an examiner that year that after I graduated would have been $20,000 a year,
Hmm.
which was, even back then, it wasn't very good. And yeah, and so it was the only job offer I got out of when I graduated. It was the only job offer I had, so I moved to DC, and I didn't know anything about what DC would be like. But looping, kind of tying into what you're saying, I really liked the DC area a lot. It was most of the people that live in that area are from a different part of the country or a different part of the world, and they're a little bit more open and friendly.
Yeah.
And also professionally, it's a little bit more based on your merit than it is based on your connections.
Hmm.
Whereas Boston's a little bit more, about your connections. If you have like Harvard or BC or certain ties, whereas DC
I mean,
wasn't like that.
I don't want to come across as if I'm putting Boston down. I mean, there are people that go there and love it. It's distinct and it's got character and flavor and it's got a lot of cultural offerings. Um, this area felt like a better fit for me. As I tell people,
Yeah.
I see DC, the DC area, or referring to it as DC in general. I refer to it as the southernmost of the East Coast cities. It's still first and foremost an East Coast city, in my view, but it's got that blend of Southern feel to it. And, it's interesting. You go right across the river to Northern Virginia, and it's actually palpable. You start to get that feel of the South creeping in, and even if you go down to Richmond or
Right,
Williamsburg,
right.
the folksiness there really starts to come out.
Yeah.
So we're right on that line, and the suburban areas here are more similar to what I grew up with.
Oh, really?
Yeah, I think so, especially where I'm living in Gaithersburg.
Yeah.
Just in terms of space, in terms of approachability of people.
Hmm.
Um, yeah, I've been in Gaithersburg since well, I moved to the DC area in '96, moved to Bethesda in '97, and moved to Gaithersburg in 2002.
Okay.
And I've been here in the Gaithersburg area. When I first moved here, I was in a up to a townhouse that's about 2.5 miles away from where I live now.
Hmm.
And so I've been in this little pocket since 2002, and it's really a nice place to live.
It's interesting how people, when they move to the area, to the DC area, they tend to stick with whatever they started with. Like if they move to DC, they tend to stay in DC. If they move to Northern Virginia, they tend to stay there.
Yeah,
Same thing with the suburban Maryland.
yeah,
Um, I moved to Arlington, Virginia
sure,
when I first moved there, and then I ended up staying in Northern Virginia. I ended up moving to Fairfax
sure.
and stayed in Fairfax until I moved to Massachusetts.
And what
And
took you back to Massachusetts?
well, so I was in DC for almost 20 years. Um, in 2001, 2002, we had the internet bubble burst. We had telecom and some other energy, some other kind of financial market catastrophes that happened around 2000, by the time 2001 came around. So that really affected business, and business started to slow down, and some of the work I was getting from some of my clients started to slow down, and then 9/11 happened, and then it got worse. It just kind of slowed down a little bit more, and I thought that Boston would be a good opportunity for me because a few of my bigger clients were in the Boston area, and so I started looking at some opportunities in some of the firms up here, and I got a great opportunity to join as a full equity partner at this firm in Boston, and things were still rough economically, but I thought that there was more going on in terms of on the East Coast at least. If you compare it to anywhere else on the East Coast, there's a lot more venture capital money and technology that was coming out of Boston, so I thought it would be a good move, and that's why I moved up here. And I grew up in Western Massachusetts,
Which is what
so
you mentioned earlier.
so in a way, I was coming back closer to home, and but I still miss DC.
Yeah,
Yeah, I still miss it. I have some mixed feelings about having made that move. I think DC was pretty cool. It's
but you can always come on back.
yeah, but then layers to that, like have kids, and yeah, it's complicated. But but it is interesting to live in DC as a lawyer because you there's a lot of lawyers, a lot of lawyers in DC, and
There are, but working remotely, I'm not going downtown so much anymore. And I think,
do you miss it?
no, I was about to say occasionally,
Yeah.
but no, it was an hour commute each way on a good day.
Mm,
And, that if I were driving, um, yeah, there are there's the K Street firms and similar firms, and that's not my style of practicing.
mm-hmm.
I'm much more casual, and I think you are, and working remotely and for yourself gives you quite a bit of flexibility.
Yeah.
And it, less pressure and it's easier to enjoy life.
That's nice. Yeah. I do miss DC. I miss being in the city, opportunities to go out to eat, and a little bit more social interaction.
Sure.
And we had that when we were in Tyson's Corner in Virginia. There was a lot going on there. A lot of,
Tyson's has exploded.
yeah, even more than we were there, right? It
Oh God,
was,
yeah. The other day I had to go down. What was I going for? Oh, I was going to meet Sam. You remember Sam B? Sam Burkholder?
oh yeah.
We were meeting for lunch, and I thought it would take me 20 minutes to get there. It's
Oh my
a
God,
45
no.
or 50-minute drive, which just,
Yeah,
yeah, it's huge.
that's funny. Yeah, it's very, very congested, very busy. Um, I liked it. I lived in Virginia, so the commute wasn't too bad. But getting in and out of Tyson's Corner too, even back then, was pretty hard.
Yeah, yeah.
It was good though. It was good. I met John Cougar Mellencamp at the mall.
Are you serious?
Yeah, he was putting milk in his coffee when I was doing the same thing. We were like shoulder to shoulder.
Was he John Cougar, or was he Cougar Mellencamp, or was he Mellencamp?
He was the version that just had um, double bypass surgery on his heart. He had the scars.
Wow,
Literally just came out of surgery, and he was doing some concert in DC. And so I don't remember his particular name, but he was well into his 50s at the time.
that would have been Mellencamp days.
Yeah, and actually, when I was walking back to the office, I ran into him again, and he was walking outside the exit door, lighting a cigarette,
That's oh God.
and mentioning how he wasn't supposed to be doing this.
So you actually chatted with him, huh?
Yeah, yeah, I chatted with him both times when we were getting milk, and then when he was lighting a cigarette. It was funny.
That's interesting.
And Sandra Bullock, I missed her. She was there the day before at the same Starbucks.
Huh.
So,
My I've seen people out and about, Wolf Blitzer having dinner
right.
or, other political folks. Years ago, I was visiting some friends in Chicago, and we are out at, it was Kingston Mines. It's like a blues bar.
Mm-hmm.
And I see this really large person come in the door, and he comes behind, and I feel his belly slide across my back, and I have to kind of lean forward.
Where was this?
It was in Chicago.
In Chicago. Okay.
And the woman, the friend of mine across the table goes, "Oh my God, that's John Candy." He was,
Wow.
yeah. And probably the most famous other celebrity that I've ever met was Buzz Aldrin. He
Wow.
was personal friends of a client of mine, and it was just really random the way it came out that the client knew him.
Mm-hmm.
And the client managed to set up a meeting. It was so yeah, he a lunch meeting, and I was surprised. I come back from lunch one day at the firm I was at, and I walk in, and the woman at the reception desk says, "Ken, Buzz Aldrin is here to see you." I went, "What?" It's like,
Wow.
yeah. So, that was a really, really interesting conversation. Um, I still remember I said to him, "So what's it like to walk on the surface of the stage of Dancing with the Stars?" Not the old "what's it like to walk on the moon" question, but it was like a kind of a curveball question. Just being funny. But the conversation was really sort of philosophical in terms of, you know, why do we do space exploration? Will we really ever get to the point where we can get our own species off the planet? Because it's
Mm.
not an easy thing to do.
So you talked to him about that?
Yeah, yeah.
Did you get any hints as to whether it's a conspiracy and we actually never went to the moon?
I wasn't going to go there because he would have punched me because he's
Well,
done that.
was that even a known theory back then when you met him? When did you meet him?
This would have been like 2006, 2007 time frame.
Because now a lot of people are talking about that. It's funny.
You see, yeah, it was even back then,
It
even
was
before that.
something.
No, there were people that accused him of not real of it being a hoax,
Yeah.
and he has punched people. It's gotten
Oh,
him.
he has.
Yeah, no, when I said he would have punched me, that's legit. He has punched people. He's gotten really pissed off at people that have, you know, suggested it,
Wow.
and it's scary how many people out there, like on the Facebook postings, where somebody will post a photo of the from the Apollo program, and all the comments start popping up about, oh, it wasn't real, and they see this and they see that that proves it was done on a sound stage. Like, oh, look at the sky. There's no stars in the sky, from the surface of the moon. Why won't you see? Well, well, it's because there's so much light being reflected off the surface of the moon, it's blotting out the star. They just don't want to hear.
It's nothing like a good conspiracy theory. I think that
Don't get me started.
they're entertaining. They're entertaining. So, anyways, that's awesome. That's really cool you
Yeah,
met him. That is really cool. Who was it? There was a restaurant downstairs before we moved to Tyson's Corner. We had this office in DC at 1100
I,
New York Avenue.
I started there, and then 2 months
Started
later,
there,
we were out to
and
Tyson's.
there was an Italian restaurant downstairs that was run by this family from Italy, and I got to know them really well.
Are you talking about in the building itself, or were you talking about the cafeteria that was like a block away?
No, that in the building itself, it was just downstairs. Um, yeah, it
I
was still
don't
there.
remember. I don't remember that one.
Yeah. Anyways, I was there one time having dinner, working late and eating some food, and um, what was the name of that? Remember that movie 10?
With
Remember
Bo
the act
Derek?
with Bo Derek? Yeah, Bo Derek
Yeah.
came in. Bo Derek came in,
Really?
and she had a big party with her. And I remember telling the the manager in charge, who I'd gotten to know really well, and he thought I was messing with him. And I'm like, no, that's Bo Derek.
That's crazy.
And then one of the waitresses went and asked her, and she said, yeah, I'm Bo Derek.
God.
It was so funny.
Yeah, and every time you hear Ravel's Bolero, it's like you think of the movie.
Yep, yep. Um, so you get to DC, and now what was the firm that you joined when you first came to DC?
Rothwell Fig.
Oh yeah, yeah.
Rothwell Fig.
Um, awesome. So yeah, DC is a great place to be as a patent attorney, I
Yeah,
think.
yeah, yeah, yeah. I got, some good litigation experience when I was at Rothwell Fig. About 70 or 80% of my work there was litigation. And
Oh really? Tell me about
yeah,
that.
yeah, I did litigation support, mainly prosecution and some opinion work when I was at Fish. Um, at Rothwell, I did a lot more litigation.
Were you doing
Uh,
depositions,
I did some
defending, taking?
depositions. I did depositions. I did discovery. Um, did some pre-trial briefings.
Did you
Uh,
work on expert reports?
never got to the stage in the litigations that I was on. We never got to that stage, but it was good experience.
Totally. Yeah, very good experience.
And I know you did some litigation also, correct?
Yeah, I did. I've been doing some litigation on and off since I was pretty young. And then even when I wasn't doing litigation, we had a really close relationship with the litigators.
Yeah,
Um, Things were different back then. There was a lot more
interplay.
interplay between the prosecutors and litigators, even at Cushman and Pillsbury. But especially when I was younger, I worked at this 20 lawyer firm. The name of the firm was Greenblum and Bernstein.
Here?
Yeah, in the
Yeah,
DC
I know
area.
them.
Yeah,
Neil
and
Neil Neil Bernstein, or is it Neil Greenblum?
Neil Greenblum.
Yeah,
Yeah.
my daughters are in school with his granddaughter.
Oh wow. Yeah.
Yeah,
Yeah. So I worked there. Shoot, I was I was pretty young. I hadn't finished law school yet. I started working for them, and I was really busy doing prosecution, really busy. But every Friday we would have a luncheon, and we would go over all the cases, and the litigators and prosecutors all would all get together, and then I had it was I tortured myself doing it, but I got involved with the litigation, doing some briefing for Neil in one of the ski cases. Solomon, I think we represented Solomon in one of the ski litigations.
It wasn't ski boots, was it?
Yeah,
Were you up against Fish and Richardson?
maybe, I don't even know. I don't remember.
Because when I
Maybe.
was at, what was it, Solomon versus Reichley
No, it wasn't Reichley. It was
or
Solomon.
Nordica?
Huh?
Who was the other party?
I don't remember, but
Was
I
it
don't
boots
remember.
or skis per se?
It was the boots. It was the boots, and it was Solomon. Our client was Solomon, and it was a big name. I don't remember it being Reichley though.
I could be wrong on the name, but the reason my ears perked up was because when I was at Fish,
Yeah,
they had this major litigation going on, and there was a room that was filled with probably 100 different pairs of ski boots. It was
yeah.
all the exhibits, and it's like, I can't, if it
It
were the
was
same.
fun. Yeah, it was fun because you're like playing with the boots, and you got the diagrams and the patents, and
You know
yeah,
what's interesting? What's interesting, Tony, is the older we get, the smaller the world becomes.
it is small, and especially in patents, and especially in DC. So I did that, and then when I joined Cushman, Darby and Cushman, I got involved with the litigation there. Involved, it was like it was a real estate software system, a patent on that, and I was handling all the expert witness stuff. So the technical and damages expert witnesses, and helping them with preparing the reports. And then I don't know if you remember, but I did a lot of work for my biggest client. One of my biggest clients was Cognex Corporation. They did
Sure.
machine vision. They were out of Boston.
Are they still in business? Do they still
Yeah,
exist as
yeah,
such?
they're still pretty busy, pretty big. And I remember National Instruments started moving in on one of their customers, and I kind of basically orchestrated the whole plan to sue National Instruments.
Wow.
Met with the executive team, and we went through all their patents, chose a few patents that we would assert, and then assembled a litigation team. And then
Huh.
at Pillsbury, we sued on behalf of Cognex. We sued National Instruments. So that was my, big participation and entry into doing litigation. And then since starting my own firm in 2004, I've represented, well, even actually while I was still at Pillsbury, I helped a client get a patent on an anti-rollback device for wheelchairs. And there was an infringer that copied their device out in California. We filed a lawsuit with a motion for summary judgment with the filing, and then
Hmm.
they settled right away with us. And then
Interesting.
a few years later, when I was up in Boston, I sued another company in Massachusetts based on the same patent, and then we mediated it, and we settled it in mediation.
Good for you.
And then it escalated, and then we there was actually a referral from Pillsbury, and it was an Italian client. We defended them in litigation in Boston. The firm handling the case for Exergen was Fish and Richardson, actually,
Hmm.
and we were on the other side of that case. And
You were talking about how things seem to be a little bit more segregated, if you will, between litigators and prosecutors these days. And, you know, it's a shame because I think, I mean, there are people that do strictly prosecution and
can
they're
I
good at it. But I
can I
do
stop
think,
can I stop you for 1 second?
sure,
Just for the audience, and we've discussed this in other podcasts, but in patents, what there are patent attorneys that spend a good portion of their time helping clients get the patents through the Patent and Trademark Office, and those attorneys do the term that we use, which can be confusing to people that don't live in our world. We call that prosecution or patent prosecution, and we call those attorneys prosecutors. And not like a prosecutor like in a criminal case. It's someone who helps get patents through the Patent and Trademark Office, and you present legal arguments and stuff like that. Litigators are people that either defend a patent lawsuit in court or file and prosecute a patent litigation in court. Those are the litigators. So when we're talking about prosecutors versus litigators, that's what we're talking about. And you go ahead. Sorry to
Yeah,
interrupt you.
that's okay. What I was going to say is, I think, although there are prosecutors I know who've never done litigation, and they can be very good. But in general, I think exposure to one really, really helps improve your practice on the other.
I agree.
And what I analogize it to, and this may be a comparison that would be lost on a lot of people. There's a famous the Escher drawings, the sort of funky geometric drawings where one thing changes into morphs into another, like stairways that seem to go on forever. There's one famous drawing that he's done.
There's
You may
illusions, like illusions. If you look at it a certain way,
almost,
mhm.
and there's a famous one of one hand drawing the other, sort of a yin and yang kind of thing. I view prosecution and litigation almost in that way. Familiarity with what it takes to prosecute an application can help litigate, because you'll understand what you're looking at going through the history of the application, read it, understand what the give and take between the patent office and the applicant really indicates. And having become familiar with how anything and everything that is said during prosecution can help litigation or be used against you in litigation, you develop a sensitivity to minimize those kinds of extraneous statements that could end up coming back
Right.
to narrow the focus of the patent. So
Right.
I think it's really, really good to have exposure to both sides of the patent house.
Yeah, I think my frustration has been, and I made some comments on LinkedIn about this, has been that some firms, more than in the past, have decided to specialize only in getting patents in what you call patent prosecution. And the priority has changed a little bit in that the goal is to get a lot of patents filed on behalf of the clients and to do it very economically. And I think that's always been the case, but those law firms aren't actually litigating those cases. And I think that it's possible that they might not appreciate, some of those firms, not all, but some might not appreciate the way they're doing it and how it might impact on the litigation because of the business motivations. And there tends to be a little bit more of a siloing between the two because it's hard to do both. It really is hard to do both. And I liked it better when there was more back and forth.
In terms of firms siloing as between prosecution and litigation, sure, I see that. That by itself, a firm tending to specialize. Well, I'm sort of ruminating on what you've just said as you say it. What I was really thinking about as you were, relating that was how, yeah, there are firms that specialize in mass production of patents. And there are other ones that take a more curated approach or craftsman approach to it. And the thought that was really going through my mind was how there are many, many different ways to prosecute, to prepare, to write and prosecute a patent application.
Sure.
And what I think is important is to be able to shift back and forth between the approaches depending on what the client wants and what is the value of the patent to the client? Why does the client want the patent? There are some clients that want just patents as just to be able to say we have so many patents. I think those tend to be ones that clients that participate in patent pools where everybody shares and licenses and cross licenses to each other. And your rate at which you can license other companies' patents will be affected by the number of patents you put into the pool. And that may be
Yeah.
the case. There are other clients where, and I think this tends to be more along the lines of startups, where each and every patent that they're getting at the get-go is really, really important. And so you really want to spend the time to craft it to give value
Right.
so that the patent itself has some real value to the company, whether that is to cover what the company is doing or intends to do, or to be broad enough to cover and prevent other companies from doing what the client is doing.
Yeah.
But I think those are the situations where you want to give it more thought and real care in how you prepare and prosecute the application.
Yeah, that's a good point. I think the it really depends on your clients and what they want. I think sometimes clients don't really know what they want, so it's an interesting. I think it's like a chicken and egg problem. Like the clients say, "Get me a patent," and then they think that means that they're going to get certain protection or certain value out of it, and then the patent attorney follows the instructions of the client, gets them the patent, and maybe works with an inventor. The inventor says, "Focus on these arguments," and I don't know who's guilty, but sometimes neither of them has that conversation as to what are people going to actually be doing 5 years from now. Is the company that's getting the patent and the competitors going to be doing it this way, or
I think
or are we working on an argument that a particular inventor has at that point in time that may or may not relate to or overlap with what's actually being done in the market in a few years?
you said you don't know who's guilty. I think it's incumbent upon the attorney, the practitioner, to explain to the client what's going
Yeah,
on and give the client the option to
yeah,
choose A or B.
yeah. I think there's some truth to that. I think you need information from both directions, and it's a partnership. Um, One of the things that so the patents so there's this section we didn't talk about this but just briefly. So when you get a patent for a client, you you want to describe what the protection is that you're going to get. So you disclose your invention, and then there's this section in the patent called the claims, and they're like dictionary definitions, and those claims describe what infringement would be. And if those definitions are too broad, then those definitions will describe what was done before, what was in what they call we call it the prior art, and therefore that claim would be invalid because it's just describing what was in the prior art. But if they're a little bit more specific, they can very eloquently describe what you need to do to infringe, and they can effectively create leverage, allow you to block competitors from a particular part of the market. And ideally, that's what you want to do.
I'm sorry, I had to respond to something I missed. You, are you there?
Yeah, yeah, yeah.
Oh, okay. I'm so sorry. Yeah, and I assume you were summarizing or explaining for the folks who watch. And
Yes, yes, yes.
yeah,
Not explaining it to you. Um, I'm explaining it to the audience.
that's why I looked up. I had to just respond to something really quickly on a text. I looked up and it's like, oh, he wants me to speak. And I was caught a little
So
flat-footed.
whatever I just said, Ken agrees with, and he can't.
An attorney
I'll
who has
confirm.
nothing to say. Yes, we
I'll
do
confirm
exist.
afterwards. I'll show him a transcript, and I'll confirm with Ken that he agrees with what I just said. So let's
Okay.
assume that he agrees. So
Okay.
bottom line is, whatever you do, make sure it's not stupid. That's my point.
I tell people patent prosecution is very much like you want to Mirandize the client and explain to them that anything you do or anything that you say during prosecution can and will be used against you by the opponent when you go to enforce your patent in court. Anything that you say that the accused infringer can latch on to try to narrow your claims or to interpret your claims in a way that narrows what they describe or what they cover or what they protect, it
Right.
will be done. And that is, going back to the comment I made about litigation and prosecution having sort of a symbiotic relationship.
Yeah.
When you start to approach prosecution with that mindset, you learn to become very, very careful in what you say. And that antenna is it always should be up.
Right.
You don't want to say this is mandatory for something to be covered by the patent, or this is a mandatory component of the inventive product. Because as soon as you put something like that on the record, the accused infringer is going to be looking for a way to do without
Yeah.
that mandatory component. There are, to look at things or to describe myself or explain myself, thank you, a little more broadly. There are, for example, ethnic groups or religious groups, you can say, like for you, for example, you're Italian. Are you an Italian American? Are you an American Italian? In other words, which attribute of you do you put first? In other words, if you're an Italian American, you're first and foremost an American who has an Italian background. If you're an American Italian, then you see yourself as Italian who happens to live now in America. On the patent law side of things, as I see it, there are some practitioners who view themselves as first and foremost attorneys who happen to have a technical background. There are other practitioners who view themselves first and foremost as techies who happen to have gone to law school. In other words, where is that emphasis?
Mm-hmm.
In my view, to do this job well, whether it's litigation or prosecution, you need to really blend both of those sides of your background to work together. Yeah, I do see myself as an attorney. But I'm an attorney who's comfortable and enjoys working with technical subject matter, understanding how it works, being able to explain it, being able to argue based on it. But I'm still arguing or advocating on behalf of the client. It just so happens to be in the realm of technical subject matter. In other words, it's a blend of the two.
Right.
That's the way I see this practice, and it's how I approach it.
Yeah.
And I view it as an exercise in advocacy.
Yeah, I think that's a good way of looking at it.
I'll get off my soapbox now.
No, that's a good way of looking at it. I think, and at the end of the day, you need to do it in a good way. You just need to do a
Yeah.
good job, and it has to be targeted, I think, on something that's relevant, to what's actually done in the market. If it doesn't exist in the market, then maybe there's some value to it, but you're just getting a patent that's never going to be, it's never going to read on anything that anybody's doing.
Either exists or is feasible to exist.
Yeah.
If you're talking about something that is so much vaporware or so far in the future, like, oh, time machine. Sorry, that won't be, here's another, I guess, teaching point. It won't be enabled. In other words, we have no way of doing time travel right now. So yeah, I could draft an application that says I'm going to come up with a time machine, and I draw a bunch of black boxes to represent the magic that happens. But there's no, so it's so far in the future that a person of skill in the art won't know how to do it, and that patent will be meaningless.
Yeah.
It
One
won't
of the
be
things,
enabled.
one of the things I see this happens a lot when I'm meeting with inventors, is sometimes they really have a good sense in about the fact that you can do it in different ways.
Mm-hmm.
But also inventors, generally speaking, have to implement their invention. So they're focused on considering, because of where they are and who they're working for, they're focused on what makes the most sense right now in terms of how to make this invention, how to make this thing work. And they're not thinking in terms of a competitor is going to look at the patent and do it a different way just to get around the patent.
And
And
that's where skill as a patent practitioner really comes into play.
yeah, and that's where, like, when I'm having that meeting with the inventors, that's where I talk to them and say, well, I want to know how you're doing it, but I also want to know what are the other possible ways of doing the same thing, and how might a competitor do it differently just to get around this patent. In other words, I want you to include, when you're brainstorming the various ways of doing this, I want you to include the stupid ways,
Yeah.
because there's a famous case. Do you remember the Gentry case? It's
What's the subject matter?
it's a case where it's actually a pretty simple case to explain. So it was a case where they had this sofa, and there was this part of the sofa where there were these controls located at a certain location on the sofa.
I think I remember this, and it was
And
specified in the
and then
claims.
you can operate those controls to operate whether it reclines, I think, and do certain things. And the claims that were originally submitted said that the controls had to be at a certain location. And what the patent attorney did during the prosecution, to their credit, is they modified those claims to be generic, to basically say that the sofa has controls located on the sofa, but they didn't say where those controls were located. And the disclosure of the invention only had one embodiment, and it showed the controls at a particular location. And what the defendant argued was, your generic claim that doesn't specify where the controls are is not supported by your original filing, because you only included one embodiment and you only showed the controls at this location. And at the time, that argument usually was made in chemical cases, in cases where it's what they call a non-predictable art. Whereas a simple mechanical case, people argue that that's a predictable art and you can get away with that. And the Federal Circuit said, no, you have to, that generic claim is not supported. You've got to provide other embodiments. You got to show other versions of that couch of that sofa with the controls in those other locations in order to fully support the generic claim that says that you can put them anywhere on the couch.
Here's my question for you. I remember the case generally. Um, and you said the attorney took it out. Did the original claims go in with the location specified? Because if the original claims went in without specifying the location, in other words, when did the attorney take it out? During prosecution or before it was filed?
You're coming up with a nuanced argument that I'm aware of. The holding in the point of the case was such that you cannot support a generic claim without without more embodiments, without more disclosure to support the full scope of that generic claim. So just submitting that generic claim when you originally file it, it's not a matter of whether the claim language is supported by the original filing, it's whether the specifications supported the claim.
My counter argument to that is the claims as you file them they support themselves. And in other words, if I see something that says it's got a control somewhere on the couch, and even though the spec might only show on a specific location, as long as the specification, as long as the specification doesn't say anything about that being critical, I would argue this is broad enough,
Yeah.
or this claim is filed is enough of its own support to allow me to get that subject matter back. But to what I was saying
I
earlier
I
about
think
any
the I think the lesson is that if you don't put more than one embodiment and you don't specify in the disclosure other ways of doing the same thing, then there's a risk that that generic claim won't be supported.
exactly,
And I think that people were very surprised when that case came out because it was unusual for that type of holding to exist in a simple mechanical case. And it also was surprising because now patent attorneys, when a case like that might only cost a certain amount of money to prepare, now they've got to make it more complicated. Now they've got to provide more embodiments and more variations. And what I tend to recommend to any client is that we want to describe the various ways of doing this.
absolutely,
And that was a case that really kind of illustrates the importance of that.
absolutely.
But yeah, so that's important, and I think you need the inventors to kind of be behind that and give you some of those alternatives, and sometimes patent counsel will get caught up in the inventor's priorities, and the inventor's priorities is to implement it at a specific time for a specific purpose at a particular company, and not think through the various other ways of doing the same thing. And I think that you can get in trouble if you focus too much on that.
And that doesn't surprise me at all. And
Yeah.
also, in a related vein, not only is it the question of or the issue of different embodiments, but that I think the practitioner needs to be aware of and help bring out. But I think it's also important for the practitioner to be thinking more broadly than just what did they come up with. In other words, to think in terms of
Yeah.
what I refer to as inventive concept rather than just
Yeah.
specific embodiment. Um,
Yeah.
that's sort of a nuance that a lot of people don't get. They sit down and they focus on what was describing the embodiment and maybe some alternatives
Yeah.
without really recognizing what's the
Yeah.
broader overarching purpose or the magic, if you will. And you want the application to convey, what's the overall principle here? What's the benefit? What's the sizzle to the steak?
Right. Right. Yeah. Yeah. There's so many different, in my mind, there's so many different ways to kind of come at the craft of what we do. But at the end of the day, if you don't have the patent done in such a way that the claims describe what what you and your competitors are going to do or want to do, then you're not getting the value out of that patent.
In general, yes. Unless, of course, you're a forward-looking company or trying to put down markers for the future. If those markers represent realistically
Yeah,
doable
but it
concepts.
and that's what. Yeah, yeah, yeah. No, it's an interesting process, and it's another thing that I point out is that when you're describing the invention, like this patent's going to live for 20 years. So if it can be done a different way, or you think people are going to do it in a particular way 5, 6, 7, 10 years from now, keep that in mind.
Yeah,
Keep that in mind. If you you know if you can anticipate various ways of doing it, even though you're not likely to do it in the short term, it's still worth including that.
What that reminds me of, and this is again going down memory lane, and this may be getting into too much of a conversation that's just tangential. Um, you remember the Lemelson patents?
Yeah, yeah.
Lemelson was
Doesn't he have some
notorious.
ties? Doesn't he have some
Pardon me?
ties to MIT?
May have. I just
Yeah.
I just know that he was famous for, you know, back when continuations, the expiration of a continuation application was based on when it was filed, not the earliest patent or application in the chain.
Yeah.
He had these chains that went on and on and on and on. And he, 30 years later, he's got a patent and he's saying, oh, this covers what you're doing now based on something that I disclosed 30 years ago. And
Mhm.
now the patents expired 20 years from the earliest priority date in the chain. But what I wonder is
Yeah.
the extent to which courts taking a narrow view of what a patent covers was influenced by Lemelson and the games he would play, trying to say, oh, this patent 30 years later covers what you're doing, even though it discloses something that I came up with 30 years ago.
Yeah.
Do you understand what I'm asking or what
Yeah.
I'm?
No, I get what you're saying. I think there are a number of areas in the law that have changed since, certainly since the early 90s, that you can see our response to patent holders asserting their patent rights,
Yep.
and defense counsel is starting to come up with creative arguments as to how it should be a little bit harder for them to do what they're doing, and and it is harder to look at a product. If I see a product that's on the market today based on a and a patent application is still pending that was filed 7 years ago, I have to try to revise the claims in that patent application to describe that product that just came out today. And if I don't, if the disclosure in there doesn't support the stuff that's in that product today, it's going to be hard for me to provide that claim and put that claim in there. And defendants don't like the defendants don't like patent holders being able to do that.
Yeah. And
And
it's
so if
interesting.
they're trying to close those doors, they're trying to make it harder for you to do that. So that Gentry case is an example of where defense counsel made it harder, so hard for them to do that, that patent basically was invalid.
It's interesting the thought that the mental battle that goes on in my head, because my initial reaction is, yeah, and that's really unfortunate when you can't do it. On the other hand, that's actually part of the fundamental purpose of the patent system, which is you disclose how you did it and you get your limited monopoly. And the idea is it's supposed to engender other ways of doing it. It's to advance technology. And one of the ways to advance technology is to get these other people to figure out, how am I going to do this in a different way
Right.
to get around it? So it's part of the fundamental reason for the patent system in the first place.
Right, right. So again, when I'm meeting with inventors in the beginning, I'm like, okay, you've invented this, and in the process of inventing this, you go through a brainstorming process, right? And there's 20 ideas that are out there, and you discard 19 of them, and then you come up with the way that you want to do it. And I'm telling you, as patent counsel, to to revive those other 19 ways and include them in the patent application. Because if you don't, you're going to come out with this product, you're going to get it patented, and a competitor is going to want to compete with you, and they're going to do it one of the other 18 ways.
Yeah.
And even if it's a stupid way, they're going to do it that way just to get around your patent, because you describe in the patent what you're doing, what you've patented, and they're going to use that as a map to kind of get around your patent and not infringe your patent. And that's the game, right? That's the,
You know, as I tell people, let me step back a second. I'm all in favor, not just in favor. I admire folks like solo inventors. I admire them, folks that will draft their own patent application and file it. Give them a lot of respect because the system can be really, really, really confusing. Um, in general, I look at patent law. We discussed this yesterday, I believe. It's very narrow in the sense that the subject matter is fairly precise. It's technology. Not everybody is dealing with technology on a day-to-day basis. Very narrow, but it's also very, very, very deep in the sense that there are a lot of principles that come into play in a lot of ways that you can mess up what
hmm
you're doing. So I'm all in favor of individuals, small clients, solo inventors, startup companies, mom and pop shops doing their own application. But at least let me come in and let me draft the claims for you because there's some real craftsmanship there that is developed over years and years of doing this. At least let me do the claims. Let me help you file, and we'll work together for the subsequent prosecution so that you don't walk yourself off of a cliff by saying things that are going to limit, you know, how this patent eventually is interpreted. There's just so many ways to mess up in this field.
well, you know what I say, I've got like a little story that I came up with. So you're an attorney, right? And you get stopped by the police. And you're like, well, I'm a lawyer. Police ask you a question, you answer it. Ask you another question, you answer it. I want to search your car. Sure, go ahead, search my car. There's nothing in there. A criminal defense lawyer is going to say, don't talk to the police. Even if you're a lawyer, don't talk to the police. Um, Chances are you're going to say something that they're going to be able to use against you. Um, when you and there's another saying that says, the lawyer who represents himself
Fool for a
as
client.
a fool for a client, right? And if you're an inventor and you draft a patent application, not only are those your words, which haven't gone through a patent attorney and been vetted, not only are those your words, but there's a permanent record of those words
Yeah.
that you can never go back on. And I think it's dangerous, and I particularly think it's dangerous when companies will take some piece of marketing material or something that's drafted by some inventor that works for the company and then file a provisional application and say, well, our patent counsel are going to go and they're going to rewrite this 12 months to 11 months from now. And there's this permanent record of what was said in the
Yeah.
original filing. And I don't think those patents do very well in litigation.
It's interesting you mentioned that. Two things in response. First, I was certainly not advocating, oh, just let them
No,
draft the spec
no, I don't
and
think you
don't,
were.
yeah.
I don't think you
Um,
were.
but because it's my job to protect the client from hurting themselves.
Right.
But in terms of provisional versus non-provisional, you may have been thinking about this. There was a case that was reported just recently where language that was used in the provisional application was broader. It was like, oh, this could be A or B. And then in the non-provisional, it only said A in terms of the specification.
Mm-hmm.
And when the court went and interpreted what the claims covered, they said these claims are limited to A because in going from the provisional to the non-provisional,
Mm.
you got rid of or B. And people, they will put in a provisional and a year goes by and they don't think about it. And then it's like, oh my God, we're right before the 1 year filing deadline. And they don't really get their heads back into what was going on. And they just slap together the non-pro or draft it without really going back and thinking critically about the provisional.
Mhm.
And yeah, you hurt yourself. It's important to go back and really fully reread the provisional
Yeah,
and build on that, not just replace it. So yeah, this idea of a client doing it themselves or a company doing it themselves without bringing in patent counsel to pay attention, yeah, it can be dangerous.
I think that that famous case that's still on appeal now, I think it's the, was it Bose against Google? Who was it? Google against this other company, and there was something in the original provisional filing that was argued to the Google argued that it didn't support the claims, and I don't think the argument was enough to win on that basis. So
I
what the
don't,
court did was the court bought the other argument that Google made, that these claims were submitted too many years after the original filing. So therefore, what they call prosecution latches should apply. And then the district court held in favor of Google, saying that prosecution latches applies.
that's
Because,
interesting.
because the stuff that you put in your claims that now describe what Google's doing, Google couldn't anticipate that back in the day, and now they're being surprised, and it's too many years later, and therefore you shouldn't be able to do that. And if that original filing was a full application prepared by a patent attorney, I don't think you'd ever have that problem.
Here's my question for you. And you may not know the answer. What I'm wondering is whether there were any continuations as part of this. In other words, were was it being argued that even in a continuation you can't pursue, or that it wasn't proper to have the broader claims in a continuation?
Yeah,
Or
but
was
it was I don't know how many continuations there were, but it was a filing based on the provisional, and I think there was a continuation that was filed. There was an allowance, and there was an issued patent, and then they filed a continuation before issuance, and so it was continued prosecution of the same case, and then the claims were submitted that now specifically describe what Google's doing, and and then the complaint that Google made is, well, that's been several years, and we think there should be prosecution latches, meaning that you know, we relied upon the patent being limited to this, and now you're submitting these claims later, and you should not be able to do that. And the district court held that, yeah, it was prosecution latches, and now that's on appeal. But I
the
think
reason
that, but I think that part of one of the important facts is the fact that the original provisional was was less than an ideal in terms of how it put people on notice as to this is part of the invention.
the reason I asked about continuation was because sometimes we see this in just a given application where um, if you start just a regular application, if you start with claims and that, the examiner goes and does a search, and you might even have, you get an office action and respond to it, and they may even come back with a final. And again, I may be getting too technical for the audience. Step in if you need to. But then I've seen it where you file an RCE to get some more examination, and you'd go with broader claims, and the examiner will go, "Oh no, these claims are too broad. You can't do this in this application because by original presentation you chose to pursue narrower subject matter." In that case, the answer is you have to file a separate continuation
Yeah,
application.
no, they filed the continuation. There isn't that issue.
But this is a latches question of,
Yeah,
did they just not pursue it, and would a competitor have been lulled to sleep to think that that's not where they're going with this line of applications? And that's interesting.
yeah,
That's a concern.
That's what happened. And I think it's part of the problem was the poor quality of the original provisional filing, because it was a piece of marketing material that was filed as a provisional.
It's interesting that you mention that because it puts, first off, it's always interesting how no matter how long we've been doing this, we always find, pick up little bits and pieces of information where we go, interesting. I ought to put that in the back of my mind.
But
Here's where I was going with that.
yeah,
I do it all the time. I tell people, hey, listen, do a quick and dirty provisional. It doesn't need to be pretty. It can be back of the envelope so long as it shows that you are in possession of the invention and will support the later claimed invention in your non-provisional. Because that works very well for mom and pop or the garage inventor. But what this whole story tells me is that that approach can be dangerous.
that's what I'm thinking. I'm proposing that is dangerous because it's like telling your client to talk to the police when they stop them at a traffic stop.
Sometimes though, that's the best you can do at the time, and they don't have the funds, or they're up against a deadline,
Yeah,
and we don't have the ability. And
I
maybe maybe what you do then is you say, okay, let's get this filed to stake a claim to priority for something, but let's come along as soon as possible and flesh this out some more
yeah.
to get the earliest priority date for the invention as broadly as we think we can go for.
Yeah, and I think, and I, a part of me wants to, well, not part of me, but I think that, um, there's a tendency for people to think, oh, we've got to get this on file right away because, we got to get something on file right away because we're going to go commercial with our product or for whatever reason. Um, and if the quality of that filing is not that good, you might be hurting yourself more than helping
Exactly.
yourself. And
You should.
I think sometimes you're better off. There's no such thing as a pure first to file system. I think that, people say we went from a first to invent to a first to file system. If you, if you file something that's not that good, it might hurt you more than help you. And you might still, if you take the time to do a more thorough, well drafted application 6 to 8 months later, you might still get protection that's going to protect your client. And, maybe there's some intervening prior art that exists now that didn't exist before. But you still might be better off. You still might, at the end of the day, get a set of claims that would survive litigation versus the situation where you have a provisional and now whatever was said you can't undo. It's in writing.
Yeah.
It's something that I don't know. It's something I've been thinking a lot about.
I've got this one client where he came up with a concept for it pertains to building decks.
Hmm.
And we're already on the third provisional within 2 or 3 months because he keeps having all these follow-on ideas.
Hmm.
A lot of fun. He's a salt of the earth kind of a guy out in Nebraska, but yeah, it's provisional, 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 provisional because we don't want to be limited based on the limited original disclosure.
Right, right. And I think litigators do some clever things when those provisionals are filed and how they try to kind of characterize what you're up to. And
I
I
hate
don't
those
know.
litigators, don't you?
It's a challenge. It really is a challenge. I've never been crazy about provisionals, but then I was like, okay,
Really?
well, we can still live with them. We can still argue 'em. But I mean, I filed a lawsuit against 20 telecom and cable companies back in 2011, and it was based on a patent, and the patent was based on two provisionals that were filed within a month of each other back in 1995. And something says that one of the reasons why we didn't succeed in that litigation is because the court just didn't like the case because of the provisionals.
Hmm.
there wasn't a reason why we lost, other than in my mind, maybe that, which isn't a real. It's not a good reason.
We do the best we can.
Yeah,
And as we go along, we learn. Sometimes things don't go our way. And even if it's not, you did something wrong, but we learn of other better ways to do things.
right.
I call it practice.
Yeah, right. No, it's true. Well, and I know you're talking about the judge. Because the judge did something wrong. My 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 dear Federal Circuit panel, that what do they call that rule when they just affirm the board at the Patent and Trademark Office,
And
without an opinion.
yeah, I don't know the Latin
Complaining about
term
that.
for it.
A lot of people are complaining about that rule. So you told me that you like it.
Per curiam? Is it
You like it.
per curiam?
It's oh, maybe no, per curiam something else. It's
Per curiam is for the court.
Federal Circuit Rule 37 or 36.
36 sounds familiar.
36, I think it's 36.
I know it's frustrating a lot of
36,
people.
yeah, 36 affirmance, judgment of affirmance without opinion. Rule
Yeah.
36. Yeah, there's a lot of controversy. There's been a lot of talk about their Rule 36 practice, and there's really not much you can do because there's no explanation. And
Yeah, and you can't appeal it because there's no record.
yeah, yeah. So yeah, that's what happened. So with all due respect, with all the respect, they were wrong. But they affirmed affirmed the
I'm
board.
sure they're worried about what you're saying about them right now.
I'm saying it in public. They were wrong, and they might agree with me, but there's nothing they
Come
can do
on,
about it right now.
give me some names. I want to know the names of the judges.
Oh yeah, no, they might agree with me, but they can't change their mind now. So very painful. So I know we're coming toward the end of our call. This has been awesome. I wanted to bring up, there are a couple of things that you like to do. You mentioned you like to do it yourself stuff at home.
Yeah.
You like aquariums, and you did scuba diving for 20 years, and you're only 27 years old, so that's a long
Yeah,
time.
right. Yeah, I started diving in '88. Um, what's interesting is I still remember when I was at camp, like at summer camp when I was maybe 5, 6, 8 years old at the JCC, and there was a swimming pool, and they had it. I mean, this is back in the day when it was really, really, really beginning technology, and they were letting kids use scuba gear with no training whatsoever. And if you go
Wow.
down, you go down to the bottom of a 10-foot pool, you take a full breath and hold your breath and come up, you'll tear your lungs. It's dangerous. So
And you guys were able to do that?
it blows my mind that they let us do that. But yeah, I got certified in '88. Got certified in Lake Norfolk, which was in Arkansas, Missouri border. Did a lot of freshwater, murky lake diving. Then eventually got into some dives in the Florida Keys and the Caribbean area. I did my first Pacific diving in Palau in, I think it was 95 or 96. And the problem with Pacific diving is once you've been there, you're jaded. The Caribbean just doesn't cut it anymore.
Wow.
So I dove Palau.
Can I can I
But
can I stop you for just 1 minute?
sure,
I'll be right back. I'm gonna say break so that I can find it in the location and delete this one little piece, but I'll be right back.
diving in the Pacific, I did Palau, um, Papua New Guinea, um, a place called Sipadan, which is about 20 miles off the coast of Borneo. And that was the most difficult place to get to I've ever gone to. It was like 7
Wow.
flight legs and a bus trip across Borneo. The interesting thing about Sipadan was we were on the way back, and we were 5.5 hours into the flight leg from Taipei,
Mhm.
and we got turned around and sent back because it was 9/11. I got stuck in Taipei for a week. Um, but then Bali, the kind of diving I like to do is called live aboard, where you live on the boat. You sleep, you have a cabin,
Oh,
and you
wow.
can dive 4 or 5 times a day. Um, but yeah, my last big trip was to Bali, and just the development, the coral development, and the diversity of the coral and the diversity of the fish life. Just really, really, really beautiful. And the the thing I love about it is the rhythmic sound of your breathing through the regulator and the bubbles. And I'd be just as happy going down to a spot 30 feet deep and just plunking down on the sand,
Mm,
watching the life go around in just a little area.
yeah.
Um, but I got into keeping saltwater aquariums because I wanted to have a little piece of the ocean near me at all times. Um, and I, over the years, probably had 9 or 10 different tanks. Started with a 60, went up to a 110, and a 36, gallons, and a 75, and a 105, and up and down and buy and sell to my wife's
So what dimension
dismay.
wise, like how many feet long are these tanks?
Um, the 110 was a 5 foot long by 18 inches by about 2 feet high. A 75 is 4 feet long. Like a 36 might be 3 feet.
Hmm.
But the last tank I had, it's interesting, when we were looking to move, when we were looking to buy a house, primary reason for buying the house we're in right now was because there's a spot over there that was the perfect nook to set up my dream tank. And the tank that went there, it was a custom made tank I had made when we moved in. It was 7 foot long
Wow.
by 28, I think, 26, 28 by about 25 high, 25 inches. And it was, I think, about 260 gallons. Um, and I there's a wall, there's a storage area on the other side of that wall, and with a sink and drainage and plumbing. And so I plumbed through the wall to do all the filtration on the other side of the wall. And it was really an elaborate setup. Um, the interesting thing that I found, two things that led me to shut it down eventually. Um, there were a number of times that something would go wrong. System wouldn't crash, but something like a pump might stop pumping,
Hmm.
or a section of the water flow system would lose water in it. We know
Hmm.
it, and the flow, the circulation would stop.
Hmm.
And I always caught these problems and managed to troubleshoot them. But I would always worry what would happen if this happened while I was away on a business trip, and there would have been no way for me to talk my wife through how to fix it. That always worried me because it was the system became really, really, really complex. And the more complexity you build in, the more chances there are to break down. But also, what I found was I was getting more enjoyment out of planning it, figuring out how am I going to set this up, where am I going to put the pumps, what kind of a overflow system am I going to use, what filtration method am I going to use, etc. I got more enjoyment out of the planning
Mm.
and setting up and going online and buying from the online part supplies companies
Hmm.
than I did once I actually had the thing set up and running. And it's it was a realization as to what made me tick. But the working with my hands, the do it yourself stuff, there were an awful lot of skills that I developed working with the aquariums that translate into skills that I could use all over the house.
Yeah.
I love working with power tools. I would love nothing more than to have a client that is a power tool company. Um, but
Hmm.
yeah, I do a lot of stuff around the house. and figuring stuff out where like my wife goes, how the devil did you know how to figure that out? For example, the other day she comes to me and says, oh, the refrigerator in the garage isn't working anymore.
Okay.
As it turned out, there was a GFCI circuit in my daughter's bathroom upstairs. Actually, no, there was a GFCI that was tripping, but completely away from where the refrigerator was. And once I tripped it, and once I fixed that, the refrigerator kept going off, and I had to figure out, okay, what is the circuit path through the house,
Hmm.
and which of these boxes is the one that's causing the trouble? I fixed it. Or plumbing, you know, it's like, oh my God, what's that? You've got water in the ceiling. Yeah, I'll bust open the ceiling, get in there and figure out what's going on. I've pulled
Intimidating
toilets,
stuff.
replaced
Yeah.
toilets, climb around in the attic. To me, it's relaxation. I'm focused on that. I'm not worried about all the other stuff going on.
Yeah.
And there's a sense of satisfaction being able to do this stuff yourself.
That's awesome.
And there's a lot of money to be saved.
Can I call you?
You pay for the airfare, I'll come and do it.
It might be worth it.
Maybe I should be going into plumbing instead. They make some good money.
It's, there's a lot to be said, especially going forward with the way everything's changing.
Yeah, yeah. So I enjoyed this phone call, this video. It was a lot of fun.
Likewise, likewise. Thank you very much for being on. Yeah, I think that I don't know. I really like doing this podcast. I think it's great to some of the people I have on are clients or potential clients, musicians, artists, inventors, people that do different things. And I think it's a good opportunity to just learn, you know, connect. We don't get together for lunch,
Yeah.
right? You're down in Maryland, I'm up in Boston. So it's like
You
a long lunch, and
you
it's a
asked
good way to connect.
you asked me about all my background stuff. I'm interested in your MMA stuff because
Oh, that's fun stuff. Yeah.
you I don't know if anybody's ever told you this, but you give me like a Keanu Reeves vibe. You're the lone wolf. Where how'd you get into the MMA and how long have you been doing it?
So I went to college at Western New England. It started in '83, and I remember I did soccer, I did baseball when I was younger, and did soccer for a little bit in high school, but I quit, and I regretted quitting. I wanted to stay with wanted I wish I'd stayed with it. So when I went to college, I said, oh, I want to do a sport, and I don't want to ever quit. I want to just stay with it no matter what. And it turned out I ended up joined the martial arts club in
Huh.
college, and then I just stayed with it and kept on doing martial arts since. And
Do you get into any like full contact actual
well,
fighting, so to speak?
I'm 60 years old. I did a I used I and I was busy going to law school and then working at a law firm, so I didn't really compete a lot when I was younger. I competed some when I was like 19, 18, 17, in my early 20s. Um,
Were you
back then,
taking were you
back
taking
then,
shots to the face?
yeah, a little bit, but it wasn't like the MMA stuff that came out, 5 to 10 years later. And I never did that. And then I never boxed. Like if you box, you get hit a little bit harder and a little bit more. So I did the point karate back in the day, and then I fought. The last time I fought, I was 51, and it was out in Springfield, Massachusetts. I fought and won first place in the 50 to 59 age
Interesting.
range, and then tried to fight this 200-pound black belt who was like 20 years old, and I did well against him, but he totally beat me, and it was good. It was cool, but
You we
I
were
don't fight
talking
anymore.
earlier about sports,
Yeah.
and I wrestled. I still remember in ninth grade, there was the meeting after school for football. And I still remember this to this day, sitting on the bus after this meeting, thinking to myself, I don't like getting hit. I'm not doing this.
Right.
I, I, not my thing. But Do you remember Rico
Oh
from
yeah,
Pillsbury? He was totally into karate, if I
yeah.
recall.
He did Taekwondo for a while. He and I sparred once.
Really?
Yeah, we fought. We playfully, but we fought down. We were down at the gym. Remember the gym downstairs in the building in DC? There was a gym down in the basement, and we were training. We were working out one day, and then he squared off.
He was a little
Square,
crazy.
and we sparred, and he ended up doing some thing where he kneeled down and he did this dragon sweep and he swept me and I fell down, but um, I thought he got the best of me, but he complained about his knee for about a couple months afterwards. So
That's funny. That's funny.
yeah, he's a good guy. Yeah, he did that for a while. He said he fought like semi-professionally. I think he probably did some like tournaments where you fight for a couple $100 or something like
Wow.
that.
That's
It was-
I ought to reach out to connect up with him. I haven't heard from him in forever.
I know.
I've been doing a lot of networking lately, and it's interesting to reach out, to see where people are up to. But um, just like I said earlier, the older we get, the smaller the world becomes.
Well, I'm glad we connected. I'm glad we thank you very much for doing
My
this.
pleasure.
And we got to still do stuff together. And when I come down, I don't know if you go to AIPLA at all. Hopefully I'll be able to make it in October, and we should get together.
Sounds good. Take care, Tony.
All right, brother. Talk to you
Thank
soon.
you. Bye.
Thank you. Bye.